This is Senate Judiciary Committee, March 31st, 2022. It's awful close to April. We are taking up page 629 and act relating to address access to adoption records. And I was saying this morning, as I was thinking this morning on my way up, that we've had an awful lot of testimony about this bill. It's been fairly consistent in support of the bill. So if there are places that people feel need where the changes are needed, that would be actually helpful to the committee. I think I can speak for the whole committee that we're impressed with the level of testimony and the support for the bill from both the adoptee community as well as others. So with that, I turn it over to Carrie Brown, Executive Director of the Vermont Commission on Women. Carrie,
good morning. Thank you. Thank you very much. For the record, I'm Carrie Brown. I'm the Executive Director of the Vermont Commission on Women. And we have been following the testimony on this bill since it was introduced. And one of the things that we started hearing about fairly early on in this process was concern for what about birth parents who were promised anonymity, and realizing it sort of became clear to us, as it did to others as well, that that's a challenging group to hear from for a number of reasons. And so we decided to put together a survey, just an online anonymous survey, to try to just get some additional information from the public, from people who are most directly impacted by any changes to this law, just to try to get a sense of what it was that people thought about it. And so we just created this brief survey, and you've got my written testimony, which has some more specific details in it about about the survey. But basically, we published it on February 18th was when it first went out, and we distributed the link on all of our social media channels, Twitter, Facebook, Instagram. We have a newsletter of more than 1,000 subscribers that went out to them, went out a couple of times through that newsletter. And we put it on our website, obviously. And on the February 21st, the Burlington Free Press actually published an article about the survey that included the link to respond. And so that really boosted up some of the numbers. So when I wrote this testimony to prepare for last week, we had 127 responses. We've had one more come in since then. But so the numbers that I'm going to give you today they reflect that week ago number. The survey results are on a web page that the link to it is in my testimony, and it's automatically updated. Anytime a result comes in, it just goes right to that results page. So if you're ever curious to see the more detailed results, you can just click on that link. It'll take you right there, and you can see exactly what people are saying.
I'm trying to find your testimony, and I don't. Where
is it on the?
I might have posted it last week when she was supposed to testify.
Oh, okay.
Yeah.
We're going to get updated, so we have the link to your testimony.
Okay.
But please go ahead.
All right. Great. So I'll just give you a few highlights, particularly from the responses from birth parents. So out of 127 people who responded to the survey, about 84% of those are women. And we had just out of 127, there were only 7 people out of that whole pool who said that they were opposed to adopted people having access to their birth records without mutual consent of all parties. Out of those 7 people who didn't think it was a good idea, there was only 1 who was a birth parent. So all of the rest of the people who were birth parents were in support of this. There was 1 birth parent, a birth father, who said that he wasn't concerned personally. He was fine with it, but he did recognize that there might be other birth parents who had concerns. So out of all the people who responded, 20 of them were birth parents, and 3 of them were birth family members. So people who were, part of that birth biological family, but not the actual birth parents. And as I said before, all of them, except for 1, were supportive of this of people having access to their original birth records. And then we have in the testimony, I have just a few highlights from, we asked people, please share your thoughts about this proposal. We asked them what your concerns are. And again, you can click that link if you want to see all of the responses that people gave to those open-ended questions. But we got things like adopted individuals should have access to their original birth certificate and other relevant information. Everyone should have access to their biology. Adopted people should be treated like every other citizen and have a right to their records. Someone said, I know many natural moms that were told they could see their baby in 18 years. I don't know any mom that asked for or were promised anonymity. As a person in reunion, it is very easy for children and moms that don't want contact to refuse it. And I won't read all the other ones. You can take a look at that if you want, but that's the general gist. Lots and lots of supportive comments. We also heard, we asked people, were you adopted? Were you a birth parent? That kind of thing. 48 of the people who responded were themselves adopted people, and almost 80% of those identified as women. And that group as well as a group expressed very strong support for expanding record access for adopted people. And the survey is still open.
Senator,
Yeah.
I think you have the
I
question.
don't understand.
Yeah, sorry.
I'm lost here on the statistics because we don't have it in front of us, but
Well, it's
okay.
on there now.
of the 127 who responded, are you now saying 48 of those people were adoptees?
Yes,
Oh, so they weren't birth parents, okay.
right. 48. Yeah, 48 people. 48 people.
48 people. Oh,
Were they both adoptees and birth parents?
Out of those 48 people, out of the 127 people, 48 were adoptees.
Oh,
20,
okay.
and 20 of the 127 are birth parents.
Oh, that's all? That's too bad.
Oh,
That's too bad.
okay. I thought they were both adoptees and birth parents.
I don't think so.
Okay.
Well, of course.
Please go ahead.
Yeah.
Well, so I was just saying that the link, the survey is still up, and so we could be getting more responses, and that link is active, so the results can be viewed at any time. And we're happy to provide updated results as they come in if you'd like. It's also very easy for you to just go and pop in that link and see it for yourself. And that is it.
That's it.
Senator Sears, can I ask you a question? Carrie, this is Joe Benning. I don't know why, but as I was listening to you, I was scanning the purpose section, and I noticed the word former before the word parent.
Mm-hmm.
And I'm wondering, since there are parents who are birth parents, parents who are family parents, should we be distinguishing between the two?
That's
As a lawyer, I may be reading too much into it, but I'm
Yeah.
looking at that word thinking, could that be misinterpreted one way or the other?
So that the question of the terminology, I think, is one that is better left to the people who have more expertise in adoption law and in adoption rights and advocacy. We have chosen to use, in our survey, we actually used birth/first/biological to try to cover lots of different terms that people tend to use. We didn't use former. That was not one that felt like it was a good fit for the purposes of our survey. So when I say birth parents, that's kind of a shorthand that I'm using as I'm talking now to just refer to the people who are actually, gave birth or in the case of fathers, whatever you want to call that equivalent. But that question of terminology and whether former parents is the right term, I would leave to somebody else to answer that.
Thank you.
Other questions of Carrie? Carrie, I guess I have one question. My main question is, this bill is really about obtaining birth certificates and with identifying information. as an adoptee, I think you have a right to that information. But I am concerned at this stage, someone gets that information if, for example, they're 10 years old. I realize this bill looks at adults, but, and they weren't aware, they're not aware of who their birth parent is. Does that concern you at all?
Well, I think that this, as you said, this bill is about adults. And so I think that's really the dynamics of what happens inside families with children is not something that we were trying to look at with this survey or trying to gather information about. I also, again, think that's something that's a easier question for those more expert in adoption to be able to answer.
Other questions for Carrie? Carrie, thanks so much for your willingness and for the survey, for your testimony, and willingness to wait a week to.
No problem. Thanks for the opportunity to speak.
Yeah,
I appreciate it.
so glad you did the survey, even though not that many people responded who were birth parents, but that's great you did the survey. Good idea.
Claudia Cargin, DRC. Welcome. I'm Dick Sears from Bennington County. With me on the committee are Senator Benning from Caledonia County, which is our Northeast Kingdom, Senator Nitka from Windsor County, and Senator White from Windham County, which is the three of the four southern counties of Vermont.
Yeah.
And Senator Baruth will be coming shortly. He's from Chittenden County. Welcome, and good. Look forward to your testimony.
Thank you very much, and thank you for inviting me here. For the record, my name is Claudia Cargin, DRC. I am currently the Associate Executive Director of Communications at the Adoptive and Foster Family Coalition of New York. And I myself am a birth mother who relinquished my firstborn child to adoption in 1987 when I was 19 years old. And since then, I have found him and we are in a complete reunion, and he lives here. Actually, a year ago today, he moved here. So again, I thank you, and I really do very much appreciate being invited to the table as a birth parent, especially when we are talking about birth parents. It's really, really vital to actually have the people at the table be able to speak for ourselves, especially this issue, because a lot of other people speak for us, and that's kind of what I'd like to talk about today. I'd like to start with a little bit of adoption history that's really, really rather unknown. And I think this will really give some insight to this issue and the bigger picture of it. So in 1978, the Child Abuse and Prevention Adoption Reform Act was signed into law, and a piece of that mandated the creation of an independent panel of experts in adoption to recommend to the U.S. Secretary of State model legislation for states relating to procedures and policy and adoption. And over a year, they created what was the draft Model State Adoption Act and Model State Adoption Procedures, rather a mouthful. But if that had been enacted, it would have made this entire debate and discussion here in Vermont absolutely moot. In fact, it would have made the work of all us advocates for the last 40 years absolutely unnecessary. It would have radically changed everything 40 years ago. So we would have had two generations completely grown up underneath this. But what's important is what they decided 40 years ago, that there is no legally protected interest in keeping one's identity secret from one's biological offspring. Parent and child are considered co-owners of the information regarding the event of birth. This went on to talk about how adult adoptees over the age of 18 would get unrestricted access to their records. And it states very clearly, it is not a violation of the privacy of a parent whose rights were terminated for a record to reveal the identity of such parent to his or her adult son or daughter. And then it goes on to say that the rights of access to records established by this title shall have retroactive effect and shall not be limited by reasons of prior law or of assurances of confidentiality not required by this act. And it would have changed everything. It would have allowed adult adoptees and birth parents to have access to the birth records, their entire existence. It would have given adoptees and birth parents access to all the termination records, and it would have given adult adoptees and their adoptive parents access to all the legal records pertaining to the actual adoption proceedings. And I have more details of this in my written testimony that I've sent over. But the other very important thing that came from this act is that it says, this act provides for the protection of the rights of all parties to an adoption, but the child's rights and interests are paramount if a conflict among birth parents, adoptive parents, and the child develops. So clearly, we're kind of like beating a dead horse here for the last 20 years, 40 years rather. And unfortunately, this bill didn't pass. And that part of the story is really, really important too, because it talks to why, and I want you to think about why these things don't pass and why people who speak for birth parents really, really are very concerned about protecting us from the adoptee when the adoptee is the adult. When the Model State Adoption Act was put out there and there was a ton of work put into it, it was the threat of allowing adult adoptees to access their records that Ruby Lee Feister, who was the executive director of Gladney, which was the largest adoption agency at the time, basically went on warfare. And they managed to bury this. I mean, the creation of the National Committee for Adoption, which today is the National Council for Adoption, which is the lobby arm of the adoption agencies and attorneys in this country. So the lobby for adoption agencies was created to keep records closed. So the agencies wanted the records to stay closed. The experts said, we need to make everything open. The agencies said no. The agencies won. This document has been buried. It actually took me like 10 years to find it. And it is linked on my testimony, and it's a very rare thing to actually be able to see the Model State Adoption Act. So again, this issue is framed in the same way by those people who are in the business of making adoption happen. Even the adoption professionals in Vermont are still using the same arguments, talking about how birth mothers need to have this privacy. They're so concerned about the circumstances of a mother's conception. Maybe it was rape. They're so concerned about the mental anguish, that the child, to be confronted by this child. And these are the stories that the adoption professionals want us to believe and want us to create all these loopholes and weird court proceedings, or seal those records forever and give them special permissions because of something that happened a long time ago. And not only did it happen a long time ago, but the trauma was actually on the front end. And I'll get to that. The trauma is not on the back end over here when we're looking at connection. And even this isn't a reunion issue. And I hate that we have to even talk about that, because this is about the civil rights of our children and to have them access their legal documentation. So this whole discussion is actually a red herring, because it shouldn't be about birth parents, but here we are. So again, the mothers, thank you for having us at the table, because the mothers who've lived this are not saying, again, that they were promised nor needed nor wanted any protection. I have attached my written testimony, the list from Mothers for Open Records Everywhere, more, which is over 1,300 names of mothers who have said they hereby state publicly and unequivocally that we fully support open records for adult adoptees. We further state publicly and unequivocally that we would never promise confidentiality or privacy, either verbally or writing, at any time prior, during, or after the surrender of our children to adoption. I know it's been discussed before, the surrender and subordination paper by Dr. Elizabeth Samuels that looks at the legality of the actual documentation that mothers signed. And in all the 40 years that this has been a battle on the table, not one adoption agency, professional, or anyone who has ever opposed open access, open OBC access for adult adoptees has ever been able to produce one surrender document that actually has on it written promises of confidentiality or this weird concept of lifelong anonymity. Not one. And we used to say, you know, if they did, if there was one, they would have made it into a giant poster and waved it around, but it doesn't exist. And then we have the factual research from every other state and country that has already looked at this and already done these legal proceedings. There are absolutely no reported incidents of harm or harassment resulting from post-relinquishment and adoption reunion contact. And, you know, other countries like New Zealand that had, like, you know, I think they had a contact preference at one point or another, and maybe even a veto. They got rid of it after 10 years because mothers, again, didn't need it or want it. You know, in my testimony, I also have a link to a film, which is for birth mothers talking exactly about this, to legislators to say, this is not what we want. We are being used by an industry to meet their agenda. And I ask you again, who's opposing this in Vermont? Who is waving the birth mother flag in Vermont? It's not birth parents. It's people speaking for us.
We're going to hear from them in a few minutes.
Yeah.
They're basically, one is the Network Against Domestic Violence and Sexual Assault, who work with survivors of both. And the other is the Lund Family Home, which that's a adoption agency. So there is opposition to the open records. I'm not suggesting that that's what the committee will do. I'm just suggesting that there is opposition, and I'm curious if in New York you've heard opposition and how from those groups, and how was it dealt with?
Actually, in Vermont, excuse me, in New York, we did not have, when we finally came to the final bill, we did not actually have opposition from any of the women's rights groups. The only group that actually still opposed us in New York was the Women's Bar Association. And that actually, I know for a fact, the president of the Women's Bar Association had a personal connection to adoption that affected her on that level. She actually, I think it was her mother or her grandmother who was the adoptee, or was the birth parent. And that was the only, you know, and that was just a written opposition, really, what it came down to it. We did not hear any negative protection of birth mothers issues.
Senator Bruggen has a question.
Thank you. I'm wondering, I heard you talking about the agencies together pushing for confidentiality, but you also used the term industry. You said industry. Are those two things in your mind the same thing, or is industry a different concept?
I tend to often, and I have critically looked at and examined adoption as a business, because it is very much based on supply and demand. There is always a greater demand for children to be in homes. There's more homes that want children than there are people making their children available for adoption, especially when we're talking about, you know, newborn infants. That is, you know, domestic infant adoption, whether it's open or if it's closed at this point in time. The greatest demand is still always for newborns. And in that, it is an industry. I mean, when there's a lobby, when there are, you know, when there's a profit. I mean, there's a lot of profit to be made in adoption. You know,
Who specifically profits?
the agencies that keep themselves in business and the attorneys who keep themselves in business have to pay their bills and pay their employees, and they need to make money to pay for these things. The typical, I want to say, I'm not going to be able to produce an absolute accurate 2022 number, but general surveys have shown that typical domestic adoption in this country, whether through an agency or through an attorney, is about $40,000 to $45,000 to adopt a newborn baby. And it can go as high as 70 easily, depending on who you're working with and how many different aspects there are in it. I mean, there is an industry, you have organizations and businesses who their job is just to find pregnant women to supply the babies. They're facilitators. There are those who advertise, who put together the birth parent packages to try to make the adoptive parents appealing. There's a marketing piece of it. So there is an industry.
I think I see what you mean. I guess I'm trying to figure out why it would advance the profit motive to have confidentiality as opposed to having adult adoptees able to access their records.
I could give you my personal theories on that. My feeling is, and this is based on the research, historical, the anecdotal stories of what mothers have spoken of, what we know from past practices that have been documented. There were and still can be many abuses sent towards mothers. We are actually resourceless. There's and I have it in my written testimony. Ricky Solinger, who's a wonderful, wonderful historian, says that adoption happens on the backs of resourceless mothers. I always say the rich don't relinquish, right? If you're pregnant and you have resources and you have money, you don't relinquish 99.999% of the time. If you look at birth parents, we are a resourceless group. We are vulnerable. There is a huge level of poverty. 95%, the Evans and Donaldson Institute did a study, 95% of relinquishments that happen currently happen because of a financial issue. So poverty and lack of resources, lack of support, lack of housing, lack of, anything that, that brings a human being down and creates a tragic situation where one must think about relinquishing their child for their child and their own survival and possibly their other children's survival. I mean, that's, we frame adoption as a choice that women make, and that's the way it's supposed to be. It's supposed to be a voluntary choice. But when you don't really have many other options, we often question whether it's a choice or is it just a desperate act of a desperate measure. So
if I could just, I think I get it. The thing that doesn't quite make sense to me is if the relinquishing parents are those without resources and lawyers and lobbyists, et cetera, how have they managed to create a state of affairs where their interest in secrecy is the state of affairs rather than the wealthy families who have adopted? I'm just wondering, is your thesis ultimately that the wealthy parents who have adopted are the ones who don't want? I'm having trouble matching the resources with the outcome because it seems like it's the reverse of what you would expect.
It would, right? I think there is a piece where there are some adoptive parents, wealthy, privileged or not, who would just rather not have to think about birth parents, right? But I think the majority of adoptive parents love their children and wants what's best for their children. And so they understand that having access, that their children not being discriminated against and having access to the legal documentation and having access to their genetic families, because pretty much every trauma and adoption professional agrees that that's also what's best for all parties involved. So I think most adoptive parents actually will go on that, yes, we support this and we believe that this is the right thing. I think when it comes down to the agencies and professionals, because historically adoption does have a lot of dirty secrets. And I mean, when I'm talking about dirty secrets, I'm not saying like, oh, the shame of the pregnancy. I'm talking about, overall, some of the things were just really not ethical. Some things aren't just not ethical now. And I think there is a need for a lot in the industry to hide those less than favorable circumstances. In the end, the adoptive parents are kind of the final client because they are the paying customer. And often you will see that the agencies, will, that is where the emphasis is on, that their happiness is the final happiness, because that is how, you have return business and good word of mouth. So you will see that. And I do believe actually the fear is it's control. It's allowing the two parties to speak to each other. So an adoptee is told a story, we laugh sometimes when we say it's a typical story, your mother loved you so much, she wanted you to have the best, she was young, she didn't have money, she, whatever the story was. And the agencies, they're the controlling of that story, so they tell the adoptive families that story. The adoptive families tell the story to the adoptee, and the adoptee grows up with that story. And in that story, it's all wrapped up in a pretty bow, and everybody lives happily ever after. Well, now you have, if people can talk to each other, now the adoptee wants to talk to their birth parent. And maybe the story or the perspective of the birth parent is going to be different than what the agency reported and what the adoptive parents believed and what they told the child. There's suddenly this conflict of stories. And somewhere in those different perspectives, there is the truth. And when people start talking about the truth to each other, then they also start to discover the lies. And I think, honestly, that a lot of this time that we have spent the last 40 years trying to get our children to stop being discriminated against by the governments is a lot to do about hiding the lies and the unethical treatment of both children. I mean, adoptees were tested on of children and mothers. And they like to keep it that way because they don't want to get in trouble, because some of the stuff that they did was definitely not good. And actually, I mean, I myself, I'm getting out of a 22-year abusive marriage where my husband almost killed me. He ruptured my spleen and I almost bled to death. So the fact that women, that organizations that are speaking for survivors of abuse are advocating to not allow us to at least be in the light of day, it just blows my mind. Because the other piece of it too is, the trauma of adoption. I mean, in my written testimony, I have this huge list of studies that have gone for the last 40 years as well, that talk about the known trauma of just relinquishment to mothers. Forget about the trauma that happens to an adoptee with mother-child bonding, and there's a ton of research on that now too. It's just the research of how mothers are harmed. It's known. The agencies know 95% of us have lifelong depression issues because of relinquishment. But now they say, oh, they have to protect us. Well, if a mother is in an abusive situation and her husband is, such a horrible person that she is forced to relinquish her child for the child's safety, then how come the agencies don't care about her enough then, that they're happy to take her child and then send her back to the abusive relationship? It doesn't make sense. There's a disconnect there. You can't care about mothers and not want us to feel harm or pain on one side, but then they actually contributed to the harm and the pain and the trauma on the front end. Like, you can't take us out on the back end and use us if you haven't protected us on the front end. And when you look at the bigger picture of adoption and the practices, the policies in this country, they have harmed mothers. Agencies have harmed mothers, and now they try to speak for us. No.
Yeah, I need to, I've got several other witnesses and I want to give them plenty of time. So if you could wrap up.
I certainly can.
Thank
I
you.
certainly can. When it comes down to it, again, as I said a million times before, this isn't about birth mothers. We actually don't have any rights. We have signed away our rights, whether we wanted to or not. And this is about what's best for our children. This is about getting adoptees their rights to their having their legal access. And it has nothing to do. We trust the birth parents to make the right decision when they're going through the most difficult time of their life, right? We trust them to manage this and to make the right decisions. And then 20, 30, 40 years later, we suddenly are making her into a child who needs to be protected. We have not asked for that protection. We do not want that protection. Listen to the mothers who are speaking for ourselves. We do not need the agency mouthpieces speaking for us, and we do not need protection from our children.
Thank you.
Thank you.
Thank you very much.
You're welcome. And I'm open to any questions.
I think at this
Thank you.
point, in order to get through the agenda, I need to move on to Kate Von Wagner. Thank you for being with us this morning.
Thank you.
Kate?
Peggy, could you print me those two last people's testimony, please? This one's Terry Garcia.
Good morning.
Yeah, I did.
Good morning.
Okay, so for the record, I am Kate Van Wagner. I am the options coordinator at Lund, which, as you just heard, we are the largest and longest adoption agency in the state of Vermont. And I have testimony that I prepared and sent you, which I will read. And I also just want to make myself available to dive into a lot that Claudia just presented on. I'm sure you want to hear from me potentially about the characterization she had of adoption practice in Vermont and in general. So I think I'll start there, if that's okay with the committee. I just want to make clear. So Lund is indeed, we've been doing adoptions for over 130 years in Vermont. And I absolutely hear and know what Claudia is talking about in terms of the ethics of adoption and the ethics of this practice in the way that historically agencies and entities that are not nonprofit agencies like Lund have practiced ethically or not, have caused harm or not. And I am absolutely not here to deny the history of harm and practices that, you know, it's still going on and it has gone on, practices that are not serving people with respect, with empathy, with wholehearted wraparound service and care based on their needs. And when I talk about all of the people involved, I'm talking about expectant parents, whether they decide to make an adoption plan or not, who are receiving counseling from agencies, from people like me who are options counselors. I'm thinking about adoptees, of course, and I'm thinking about adoptive parents. And I think one thing that I want to make sure that you hear, first of all, is that Lund, again, we're the largest agency in the state here. We are a nonprofit agency. We are not in the business of adoption. There are absolutely for-profit adoption agencies. There are lawyers who are making a profit off of these kinds of practices. So I am not saying that this does not exist. What I will tell you is our practice at Lund is absolutely guided by the needs of everyone involved. We, again, are a nonprofit agency. We are not profiting off of adoption. The idea of supply and demand in terms of, you know, what?
From Dr. Cypher's office.
All right, keep going.
That's okay. I'm going to keep, okay. The idea that we are somehow in the business of plying pregnant people to supply babies to adoptive families is completely untrue. What we do is we have separate social workers who work with expectant parents who need options counseling across the board. So my job, while some of it is supporting people who want to make adoption plans or choose to make adoption plans for their children, That is not the main objective of my job, which is providing full spectrum, rigorous options counseling to any individual in the state of Vermont who needs that around a pregnancy decision. And most of my work does not result in adoption. It is never my intent, nor is it my job description at Lund to be pushing adoption on people, or there is no expectation that there's a certain number of private adoptions that are going to happen. If that were the case, I'd be leaving my job. So, you know, we support people. I support people who want to seek an abortion, who want to parent, who want to make an adoption plan for their child. And the support that we provide is lifelong service. So again, this characterization that we might work with someone in an abusive relationship, take her baby to please an adoptive family, and then not, you know, work with any of the other surrounding circumstances there, is a false characterization of how we do our practice. I am a licensed social worker. I am in there with people that I'm working with, again, whether they are even thinking about adoption or not. I'm in there doing case management, mental health support, whatever counseling, whatever is needed. And what I respect about Lund and the way that we practice this adoption is that we do what is needed. And actually in the practices, we, when there is a desire for an adoption placement that the birth parent wants to make a plan, the birth parent is driving that plan. And I can talk more about that if you want, but the agency is really with that expectant parent making a plan. I do not deny, and I will talk to anyone who will listen to me when they ask me about my work and what options counseling means. Absolutely true that the spectrum of choice that we want people to have is not always the reality of someone's lived experience and in the circumstance that they're living in. So choices are constrained by poverty, by all of the social issues we have here in Vermont and elsewhere, you know, struggles with substances, housing issues, unsupportive families, you know, those are issues that constrain someone's spectrum of choice that, you know, I, as an options counselor, would want someone to have that full, the full agency and ability to make a choice that they want to make for themselves. That said, I trust, one of my core tenets of practice is to trust someone to make their own decision about their own life. I cannot have the arrogance to know what is best for someone, and that's not where I'm coming from, and that's not where Lund is practicing from. So I just want to give that context in terms of how we practice as an agency and the ethics of what we're doing. This is not to say those practices have not, you know, creeped in and been historic practices of the way adoption has been. We all know adoption was shut down, secret. You get sent away. No one talks about it. You get sent to the Lund home. I'm sure all of you have people in your lives and families and communities that know, oh, that person got sent away and, you know, we didn't know, and her baby was sent away and we never heard anything. You know, adoption as a field, thankfully, has shifted towards openness and transparency over the years. And this is why Lund, on the whole, what I want you to hear from me right now and clearly is Lund, on the whole, supports this bill. We have two small issues and concerns with the bill that I will discuss in my testimony here. But we absolutely appreciate and understand the importance of access to information for adoptees about their history. Not only because we know this from everything, all of the research and all of the practice, and we as an agency support everybody in that adoption constellation, including adoptees in our adoption department. So I'm going to jump into our concerns with H629. I don't know if any of you are following along in my written testimony, but again, Lund strongly supports adoptee access to original birth certificates. We know how crucial this document and the information can be for adopted people. The first concern we have is about honoring past requests. So there are some birth parents in Vermont who have previously signed requests for confidentiality of their name and address from the adoptee on the probate court form, which is about the disclosure of identifying information, which also has been submitted, I believe, by Christina Schuma into your record. This form does allow for this request. And I know you've heard from a lot of people saying there's not a promise of confidentiality lifelong. There's not a, you know, anyways, what I'll say is this is a request for confidentiality that birth parents have made. And they've done so with the understanding that only a judge may decide to release this information for the very important reasons, including but not limited to medical reasons. So that is the language right from that form. So this bill as it's currently written would nullify this confidentiality by allowing release of the birth parent's name via the original birth certificate. And I know we understand that in this bill, the rest of the identifying information that is held by the Vermont Adoption Registry from the adoption record and the original birth certificate have been separated out. And what I'm saying here is that a full name is a piece of identifying information that, if released in the cases where these non-disclosure forms have been signed, it does nullify that confidentiality request. So Lund is requesting that these non-disclosure requests that are currently on file from past relinquishments and adoptions are upheld. By disallowing the release of any identifying information via the registry or the birth certificate through the Department of Health, the state can protect these birth parents' choice that they have already made. I'm going to add a note here, just again in hearing from the last witness, you know, the trusting someone to make a choice to relinquish their child and make an adoption plan, but not trusting them to make the choice to request this confidentiality feels tricky to me. So these are people that have made this decision at the time of relinquishment or afterwards, and they have decided for their reasons to request the confidentiality of their name and address. You know, to assist with the intent of this bill, Lund, I let the House Committee know this as well. We are happy to contact the very few birth parents who have worked with our agency and did request that non-disclosure to determine if they wish to reconsider their non-disclosure request. Of course, people change their minds over time and life circumstances change. And our hope for everyone is that there can be openness and maybe reunion if that's desired. And, you know, people can change their mind over time. We're happy to reach out to those folks. It is important that you know, as the committee, that birth parents currently have the ability to change the request at any point, the way the law currently stands. The number of birth parents and private adoptions who choose to request this confidentiality is very small. So our director of adoption at Lund estimates less than a dozen individuals in the last 25 years. And again, private adoptions are non-state adoptions, so these represent a small number of Lund's total annual adoptions. While birth parents who request non-disclosure are not the majority of birth parents, they do matter. They have often been through intensely traumatic circumstances surrounding their pregnancies. On top of that trauma, as well as the trauma of relinquishing one's parental rights that the last witness spoke to as well, they have made yet another heart-wrenching decision to request confidentiality. And I know from sitting with people thinking through this decision that withholding their identifying information if their child requests it at adulthood is not a request that is made lightly. Lund feels strongly that this bill needs to honor and respect these birth parents' no's by not allowing the state to disclose their full names unless and until they change their request for non-disclosure. Looking forward, we recommend a second change to this bill. It must add an ongoing exception to the release of identifying information of a birth parent. As written, the bill would allow full disclosure of all birth parents' names through the registry and or through the Department of Health via the birth certificate in every adoption without any avenue for confidentiality for a birth parent. Lund believes that an option must remain under state law for birth parents to request non-disclosure of their identifying information by the state. I will add here, again, this is directed by the birth parents' wishes, and these are very rare options that a birth parent chooses to take up these days. You know, as I talked about earlier, it used to be that every adoption was secret. What we see now and we know now, and thank goodness, is that openness from the beginning, sometimes full openness, sometimes some degree of that is really the norm. It is the vast majority of what birth parents want and adoptive families want, and as they get older, adoptees want. What I'm here to say is I am extremely, believe me, as a social worker, you know, I never want to speak for someone that can speak for themselves. I have no desire to have that level of arrogance or co-opting someone's lived experience. What I will say is the reason I'm compelled to bring this information to you today is because the very few Vermonters that I'm talking about that have accessed this option and who I believe may in the future access this option to request confidentiality are not people that are going to come forward and testify in front of a committee publicly for obvious reasons. They've requested confidentiality. They're not going to come here. Being a person who has sat with and talked through and held space for and, you know, been right there with people who are thinking through these decisions, I feel that it's my obligation to be here today to let you know that these people do exist in Vermont. It's a small number of people and they matter and their voice matters in this bill. So the alternatives here, like I said, we support this bill. It is the right momentum. It is the right move to open up access for adoptees to make it less cumbersome to get this information that is theirs. We are asking for these very narrow avenues for upholding current requests that are on file and honoring those no's, honoring those decisions by those birth parents, and also making sure that there's an avenue for exceptional circumstances if someone is to need to access that in the future. So we've been working closely with the Vermont Network Against Domestic and Sexual Violence on these issues over the past several weeks. They will be bringing a proposal to the committee later today, which Lund fully supports. Again, we support this access. We understand there is great momentum for completely unrestricted access to original birth certificates, but it's my obligation here to complicate this a bit. I've worked directly with birth parents who have chosen to sign non-disclosure requests for the release of identifying information. And please hear me when I say, again, these are rare, serious choices made by a birth parent to protect one's personal safety, their mental health, their well-being. It's critical that you as a committee recognize the difficulty and complexity of these Vermonters situations as you consider the impacts of this bill. Happy to answer any questions, and thank you so much for the opportunity to be here today.
Hey, let me start with first of all, I have a great deal of respect for Lund Home. Back in the day when I ran a group home, Lund was running a group home and we worked together. We actually went on strike together with Lund back in the 70s. So, an historical perspective there. So I do have a great deal of respect for Lund. At the time of well, I'll give you a little story. Victor and Laura have a child named Stephen. And at the time of that adoption, it took 2 years before Stephen was finally adopted. Nobody ever asked Stephen what he wanted. Stephen never signed any documents of non-disclosure. And it wasn't until Stephen was in his 60s that he found out who Victor and Laura were. I assume Victor has passed away because we never found Victor. But we have to assume that Laura had not told anyone. Her own daughter wasn't even aware that Stephen existed. Now I'm Stephen. Okay? My name is Dick Sears now, because I was adopted when I was 2 years old. Went through a series of foster homes. Nobody asked me. Nobody said I don't have a right to find out who I am or what my birth certificate is. So from that perspective, at least the ongoing portion of what you're talking about, I think is unrealistic. It's not right. It's not fair, because the adoptee is not part of the agreement. Maybe the birth mother and the adoptive parents make an agreement, but nobody asked me when I was Stephen back when I was 2. Nobody asked me when I was 18 who I was adopted. Secondly, now with Ancestry.com, I found I have a second sister. So who's keeping this secret? It's just not realistic in this day and age that people can't find out about this information. But it's the government keeping that birth certificate from that adoptee. And I fully understand, as I said, a great respect for both Lund and for the network who are going to speak later this morning. But I'm just concerned Number one, that the adoptee was never part of this agreement. So their rights have been taken away from them by the government through these agreements. And secondly, that in today's age, doesn't mean much of anything when you can find all kinds of genetic. I can't tell you how many people have told me they found relatives they didn't know existed.
Of course.
By using Ancestry.com. I have a good friend of mine who found he had a brother. And his father was actually having two families at the same time. They had no idea that the other family existed. So there's all kinds of things go on that I'm sure his father didn't want anybody to know about. So I don't know how you respond to that.
Yeah. Yeah. And I mean, this is, I am not pretending that any of this is simple and black and white by any means. I mean, it's really complicated. We're talking about a very human scenario that has an impact that is real on everybody involved in it, right? So you're absolutely right. Adoptees are not involved in a birth parent's choice to make an adoption plan most of the time, unless they're a lot older and they have some rights there. You know, and so I guess what I'm asking you to consider is, again, this is not a widespread situation. And again, very different, you know, even now and in the last 10, 20 years, and I imagine this will only increase moving forward, that it is a rare exception that a birth parent would feel there is something dire enough going on that they can imagine. I mean, when I talk to people about this form and this choice, and again, most of the time it is absolutely, I don't want my child to ever have to wonder, even if we're not in contact until I'm 18, until they're 18 or older, you know, if they ever want that, I want them to have it. That is overwhelmingly how these conversations are taking place nowadays, which is a very different, people were not even given that conversation in the 70s, right? Like it was, you do this, you move on, you never think about it or talk about it again. And that's what it is. So, you know, I'm not giving a...
Could work through something on the, where there has been a declaration back before, but how can, going forward, we allow the exception when we know it's not a real exception because of the DNA.
Yep. And that is a real thing. I mean, I've been on,
be honest with people.
Yep. I field those questions all the time. And there's the honesty piece, to me, it's very clear what this form says already. And what we're saying it should remain is, I'm requesting that the state not disclose my name and address. And I'm requesting they hold that confidential. And I understand that a judge may decide to open that up and disclose that information in circumstances that are very important, right? And that is, I mean, it's an additional process for an adoptee to need to petition a judge to open up an adoption record that has requested confidentiality. But I mean, to me, that mechanism is there. And I guess what I'm bringing to you today is, through the eyes of people that are living this experience of making this incredibly traumatic and difficult decision to relinquish a child for adoption, right? And if with a layer of circumstance on top of that already difficult situation that compels them to say, for this, and this reason, you know, whether it be fear of violence, fear of, you know, full-blown mental health crisis. I mean, I'm thinking of specific people when I'm giving these examples. I really need to ask that the state, please, if it's at all possible, this is not the best thing to reveal this. Now, of course, people understand now this can open up, and it does. And I know one of the arguments that's been made is like, you know, well, if someone's then to find people through search and ancestry, they may contact 20 different family members rather than just contacting the individual, and that could cause more harm and difficulty. That to me is a bit confusing because, you know, this bill really is about the birth record rather than a search process bill. They're obviously interlinked about kind of like, what are the consequences here? But to me, it's different if someone is doing that search process via a DNA situation, that's not the state handing the clear information on the birth certificate to the adoptee despite a request for confidentiality.
Senator Benning
different
and
spheres.
Senator Ruth have questions, I think.
No, not me.
Okay, this is Joe Benning.
Hi.
I will share Senator Sears' respect for the Lund home, and I've had many people through the years as clients of mine that have gone through the Lund home. And in fact, I think presently I have at least one client who was there. You are the person who gives the explanation of options at the point of entry into this conversation. At the moment, you are giving information that there's a confidentiality option. I am wondering if your narrative changes to there is a confidentiality option, but only for 18 or 20 years before someone can come back petitioning. If you have to change the narrative upon introduction of this conversation, do you believe that there are people who will forego adopting as a result of that change in your narrative?
It's a good question. I mean, I can't say concretely, definitively, of course. I don't see it having a large impact on the adoption decision. Again, as a previous witness said, as I'm sure you can all imagine, different circumstances, someone's not making this decision because they have a whole lot of other potential options probably realistically on the table for themselves at that point. So, it becomes a counseling and a support move from there, right? And already right now, when we talk about this, it's not a promise of confidentiality for 18 years right now, or after that. It's the state and the Vermont Adoption Registry right now has this form. They would like to know your wishes should the adoptee or descendant of the adoptee come forward once they turn 18 to request this information. Is your preference that the state reveal this information or not? And I have conversations now already about the reality of Facebook and social media and, the ways that we all find each other still these days.
I'm just, the only concern, frankly, that I had about this bill was the question from a birth parent's perspective, what impact it would have on the decision to go forward or not. And frankly, the more that I think about it in this day and age, most of the people I'm representing are currently tech savvy. They have a full understanding of what might happen down the road. If you're changing your narrative in the introductory conversation, I'm having a hard time reaching the conclusion that people are going to say, oh, no, I don't want to do it now. And that's the only real concern I've had about this bill so far, because I really do believe, like Senator Sears, there is a right of an individual at some point down the line to have full understanding of what their family history is, especially for medical purposes. But searching.
The medical information is available no matter what already.
Well, okay, but I'm trying to say to myself, if I'm going to vote for this, what is the true understanding I have of the impact on anyone who might be adversely affected? And thus far, I'm not sure I'm hearing you say that anybody would forego an adoption as a result of being told it's confidentiality only for a given period of time, as opposed to it's forever.
I mean, the discussion should never be forever, this is a guarantee. So, that already doesn't exist in some ways. I think what I'm trying to insert here is, and you'll hear more about this from the network later on, is, the circumstances that we see where people are requesting this and they're requesting, every effort to not be found, essentially. It really does tend to be in situations of violence, extreme emotional distress, specific worries about, should this come to light in the future, X, Y, and Z could fall apart, X, Y, and Z could happen. And I will say, our director of adoption, when this bill first came out, did have a thought about, we don't know, I don't believe in other states this has happened, but, there's currently the safe haven law for anonymous relinquishment of an infant to a safe entity that's defined under that law. And, there's some thought of, might this push someone who's in more an extreme circumstance to use that law versus make a private adoption plan in the way that they're able to now, with some reasonable level of, you know, expectation of confidentiality, if not guarantee. It's possible. I don't know.
Senator White has a question.
I have a quick question.
So,
And Senator Nick following Senator White, and then we're going to move on to our next witness.
I guess my question is, when you're talking to people, given the social media and everything that we have right now, if you're talking to somebody about there being a confidentiality, that it would be confidential, it seems to me that you have to be pretty clear that the state may keep it confidential, but it's going to be out there because somebody can do exactly what Senator Sears was talking about, that he found out through social media and through the ancestry.com and everything, that it is very likely that it'll be out there. And do you tell people that?
Yeah, I mean, that's the reality of the world right now. And, you know, I guess I just keep coming back to, it feels like a delineation to me to be potentially kind of tentatively searched and found via these other avenues where, you know, there's always an option for, I don't know what you're talking about, there must be an error there, versus, you know, having the hard printed state birth certificate that says your names. And listen, I wish I wish there was zero need for this in the world, right? Like, I wish there were zero circumstances where people felt that this was something they wanted to do, have this be secret and not be found for the rest of their lives. I mean, we know that it is so difficult and an incredibly traumatic thing to live with for one's whole life, right? There's a lot of fear and worry and, you know, anxiety about that, if that's what you're holding. So I am in no way saying like this is the ideal situation, but I'm just trying to give some voice to, these are situations that we've seen with real people who are saying, this is going to be awful if it comes out later. There is always a knowledge that can happen in the world that we live in. You know, I do think it's reasonable to ask the state to put a little, you know, barrier up for these extreme circumstances. It is
Thank you.
a lot.
Senator Nick has a question, and then we're going to move on.
Okay, I just want to, not on the same track, but in this, Senator Benning mentioned earlier, and Senator Sears mentioned the other day when we were taking testimony, it disturbs me, and it came up as an issue for them, the use of the word former parent rather than using birth parent. And it is in the law already, but it seems wrong because a former parent is any number of people. And it's not just, and this, we're talking about the birth parent. We're not talking about a former foster parent. We're not talking about a former adoptive parent if a child was relinquished after an adoption. We're talking about the birth parent. And this whole thing says former parent.
I guess I'm not totally clear, so that may be a question for Christina Schuma. I'm not totally clear if this would apply to those categories you just described.
No. I don't believe it would, but that's the terminology that's used.
Terminology in the bill.
In the law, current law says former parent rather than birth parent. It's not something new that we're creating with this work now. This is something that's in the statute already, which is disturbing. But I mean, it could encompass all those people, even though this bill isn't talking about former being adopted. You know, that's the issue. It's about birth parents, not former parents.
I wonder, I think it is, yeah. I mean, we're talking about birth parents, and I'm not sure. So again, this may be for Christina. If there were a former adoptive parent that's no longer the legal parent, and there was an amended birth certificate issued with those parents' names on it for the child, I don't know if this then applies to that
we're not worried
okay.
about that. We're not worried about that.
Okay.
We're just wanting.
I'm running way behind, unfortunately.
So that's all I have, but thank you for all your good work.
Thank you so much for your testimony.
Thanks.
And,
thank you.
Do appreciate your perspective.
I really appreciate your questions. Thank you.
We're not going to take a break, so committee members may have to get up and move around if you do.
Thank you.
Go ahead. Rebecca Henson is next. She's an impacted citizen from the New England. She's gonna say New Orleans. You're right, Coalition, New England. Thank you, Rebecca.
Hi, thank you so much for having me here this morning. For the record, my name is Rebecca Henson. I live in White River Junction, Vermont. I'm a founding member of the Vermont Adoptee Rights Working Group, which is a core partner of the New England Adoptee Rights Coalition, and I am adopted. I was born in a state that denied me the right to my own original birth certificate until 2017, when New Jersey enacted the Adoptee Birthright Act, the result of 3 decades of work from all sides of the adoption triad, birth parents, adoptive parents, and adopted individuals themselves, imploring the state to no longer see adopted people as state secrets who pose some imagined sense of risk or threat to our own relatives, but as human beings with dignity, autonomy, and the same right to complete knowledge of our own identities that all other Americans have. I was already in reunion with my own birth family for 12 years when New Jersey finally made it legal for me to request and obtain the original version of my own birth certificate. But that document still matters to me for one simple reason. It is the true and accurate record of my birth. The original version of my birth certificate and the core biographical facts about myself listed on it is not just mine, it is me. And it's the only tangible proof I have that I was, in fact, born into this world, just like everyone else. Growing up adopted can feel incredibly isolating sometimes, even in the healthiest, most stable, most supportive of families. I didn't grow up hearing the same kinds of stories my peers did about what happened on the day I was born. Neither of my parents knew because neither of them were there. I have no photos of my mother pregnant with me, no hospital bracelets. I don't even know how long my mother was in labor for. My original birth certificate is the only documentation of the day I was born that I will ever have. I didn't know any other families like mine when I was a kid. I grew up in the 1980s and 1990s with no peers or even siblings to guide me as I navigated my tangled up sense of who I was and where I belonged as an adopted person divided between 2 families. That started to change around the year 2000 as the internet evolved from an information hub to a network of communities. I started finding and connecting with other adopted people just like me in spaces we carved out for ourselves online. For more than 20 years now, I've been an active part of a thriving, vibrant, global community of adopted people, supporting and advocating for each other. We have our own support groups, podcasts, conferences, literary festivals, and even Twitter hashtags, where we connect to each other and share our experiences and advise and support each other as we navigate family, social, legal, and healthcare structures that were not created with adopted people and our unique life circumstances in mind. Because I have been deeply connected member of this global adoptee community for so long, and because I'm an adopted individual myself, I have insights into issues that directly impact adopted people's lives and well-being that people who were not adopted often overlook, don't think about, or just don't know. Because of my position within the adoptee community, I know, for example, that when an adopted person starts thinking about trying to connect with relatives that have been lost to them for decades, they don't use their birth certificates to start that process. They start by talking to other adopted people first. They tweet or post questions on Reddit. Thinking of trying to find my birth mom. I just want to know what she looks like, really, and if I have any brothers or sisters. But I'm scared about how she'll react. What if the rest of her family doesn't know about me? Will I destroy both of our lives by searching? Please help, I don't know what to do. Adoptees who searched and are in reunion, what were you most scared of? Birth father replied to my email 2 weeks ago, but I'm still too scared to open it. Need some moral support. In my 20-odd years of active participation in the adoptee community, these are the 3 most common questions I see other adopted people ask about search and reunion. How do I start? Is it worth it? And will this hurt my birth mother or her family in any way? I have personally sat with adopted people many times myself to coach them through making a decision to look for and reconnect with their relatives. And question number 3 comes up in every conversation. Will this destroy her life or put her at risk of harm? Because just like everyone else who loves their family, the health, safety, and well-being of our own original family members is our top priority as adoptees, even if that means we never get to know them. And that's why we turn to each other for advice on reconnecting, or whether it's even worth trying at all. because no one understands the deep internal conflict over both your own safety and the safety of others, quite as well as another adopted person who's been on that journey themselves. I've offered my own experiences as an adopted person as a resource for birth mothers too, who stopped hearing from their child's adoptive family and just want to know and see how their kid turned out as an adult. They have the same exact fear about reaching out that adopted people do. Will my desire to know something accidentally destroy this other person's life? I won't bother reaching out if it's only going to hurt them. 2 decades of having these conversations with both adopted people and their birth parents proves to me that we're not on opposing sides or in conflict with each other when it comes to navigating this delicate territory. We're on the same side together with the same concerns and priorities for each other's welfare. Adopted people especially are asked to think about how our actions impact others from the moment we join our new permanent families, whether that's at birth or as an older child adopted from foster care. Our lives and our decisions are no longer just our own. After adoption, our adoptive families become a major part of what we do and who we become. Your parents risked so much just to adopt you. How would you feel if they saw you doing X or saying Y? We learn from a very young age that other people's well-being relies on us and what we do or don't do, how we do or don't behave. We are constantly defined by the best thing that happened to our adoptive parents and the worst thing that happened to our original mothers. That is how our families and society both contextualize us, and it's how we contextualize ourselves too. The only thing which laws that restrict our basic human right to the original documentation of our own births really accomplish is confirming what we've already been raised to believe about ourselves, that there's something so inherently dangerous and risky about us that we need special statutes locking us out of our own vital records. Because of the time I've spent supporting other adopted people in our worldwide community, I also know that adopted people want copies of their original versions of their birth certificates for many, many reasons. Like Julie, for example, who was adopted from foster care after she turned a year old. Because the amended birth certificate the state created for her after her adoption appears like it was filed more than 1 year after the day she was born, the US State Department required additional proof from her that she was a US citizen by birth, proof that she didn't have any legal right to access or obtain because she was adopted. Julie is one of 3 adopted people I personally know who needed their senator to advocate for them to obtain basic proof of identity and citizenship because they cannot access the one document that shows how, when, and where they came into this world. I also know that a lack of original birth certificate can also cause citizenship issues for some adopted people. I'm thinking of a young man who was adopted by his stepfather. He had birthright dual citizenship through his biological father's family, but the sealing, amending, and replacing of his birth certificate after his adoption caused him to lose his citizenship status in his birth father's country, even though he still had close relationships with his grandparents in that same country. These stories bring to light a truth that is often overlooked. Restrictions on our birth certificates affect all kinds of adopted people, not just people who were adopted as infants, but also older child adoptees. And they also have no ability to consent to their own adoptions. These arrangements are made for them by adults in their lives, and the adoptees have to live with the consequences of these decisions for the rest of our lives. Allowing redactions or non-disclosure vetoes to block our access to our own birth records will leave adopted people like Julie and like me in very real limbo throughout our adult lives. You've heard, and will likely continue to hear from non-adopted people, that restrictions around our birth certificates are about preserving birth mothers' safety. Because I'm a member of the adoptee community, I know that the majority of adopted Americans are women, and the US Census Bureau has the data to back me up on this. I also know that a large portion of these adopted women are also survivors of sexual assault and domestic violence. I know this because I'm also one of them. I know that we take women's safety very seriously. If we thought for even a moment that accessing our original birth records would cause violence for another woman in our lives, we would not support opening access to our own records. But with over 100,000 birth certificates now released in 10 states that give adopted people unrestricted rights to their own documents, we've never seen this happen, not even once. I can also say that no matter what some adoption agencies may suggest, birth mothers and adopted people are not on opposite sides of this issue. In my advocacy for adoptee rights, I frequently work hand in hand alongside organizations that represent large numbers of birth mothers, like Saving Our Sisters and Concerned United Birth Parents. They've offered full-throated support for unrestricted access to adopted people. Adoption agencies don't speak for birth parents or for adopted people. They don't spend their adult lives navigating the complexities of being an adopted person in the world by non-adopted people. I do. And so do the millions of adoptees in the US whose lives are made more difficult by restrictive laws like Vermont's that tell them what they can or can't do with their own vital records. I also want to make clear that this bill doesn't actually violate anyone's confidentiality. Birth records will still remain confidential from the public like they always have been. That's the original promise that the state made when records were first sealed. Originally, after an adoption took place, those birth records were sealed just from the public so that no one from the public could expose an adopted person, expose a birth parent, or expose an adopted parent to the public. Those records were kept publicly confidential, but they were still accessible to all the individuals involved in the adoption until the 1940s, when Vermont then amended its law to restrict access from even adopted people ourselves. That confidentiality isn't going away. That initial confidentiality is not going anywhere. And birth parents will still have the option to express their wishes, not for just having a name known, but whether or not they want to actually be contacted, have any kind of relationship from the adopted person using a contact preference form. That takes away a lot of the stress and worry that comes with a question of whether I want to search or try reuniting. Having that answer on a contact preference form as opposed to just being blocked from information entirely takes away a lot of that stress and worry and fear that's felt on both sides of the equation. It's not a question, it's not an unknown. It's a way to know ourselves the way everyone else has the right to know themselves, and also to respect the wishes of the women who gave birth to us to either have a relationship or not. It's a much clearer, much respectful way of facilitating those interactions if and when they occur, in a way that's much more dignified than just a no or redaction marks is completely being blocked from your own part of yourself. I hope that as you hear more testimony on this bill, you will consider and remember that OBC access is about equal rights under the law. It's also about restoring rights to a marginalized group whose rights have been curtailed through no fault of our own. No one can say they support equal rights for adopted people, but only with certain restrictions. There's no equality with restrictions. Anyone who supports restrictions on birth certificate access does not support the rights of adopted people. I would ask that you ensure all Vermonters have the equal right to connect with themselves, understand themselves, and how they fit in not just America's story, but as Vermonters too. Thank you very much.
Thank you.
Thank you.
Are there any questions? Rebecca, thanks so much for being here.
Sure, thank you.
Our next witness is Jessica Bartlett.
Where's Jessica?
Jessica.
Good morning, committee.
Morning.
Thank you for having me. For the record, I am Jessica Barquist, and I'm the Director of Policy and Organizing for the Vermont Network Against Domestic and Sexual Violence. And I want to start by thanking the committee for the opportunity to provide testimony today on H629. We were not following this bill when it was in the House until the very end of the process when some concerns were raised. And, since that time, we have listened to and have heard many of these stories that these adoptees have been sharing with the legislature about their struggles in obtaining this really critical information about themselves and just how important that information is to adoptees. And we fully agree that adoptees have a right to their information and wholeheartedly support the efforts of this bill to make the process of getting that information easier and more streamlined for adoptees. However, we are pretty concerned that this bill eliminates any path forward that does retain that confidentiality for that small, narrow percent of birth parents who may need it. And I think, threading that balance between keeping people safe and allowing everyone their access to official documents is a really difficult and important balance for the state of Vermont to get right. And we believe that this bill shifts that balance just a little bit too far in one direction. And as you all know, as the statewide coalition on issues related to domestic and sexual violence, really our primary concern is the impact of legislation on people who are victims of domestic and sexual violence. And so we feel like maintaining a very narrow avenue for confidentiality is critical for birth parents who have experienced or who are experiencing domestic or sexual violence and who believe that the knowledge of that adoption would put them at risk of harm. So we really believe that all adoptees should be given their information, including their original birth certificates. And at the same time, there needs to be that pathway to requesting and seeking that non-disclosure for birth parents, which we know is not a guarantee or of complete sealing and protection of that personally identifying information. But on those specific legal documents from the state, that personally identifying information is both in those documents within the adoption registry as well as on the birth certificate. And when I'm talking about personally identifying information, we are relying on the definition in the Violence Against Women Act. And I put the full definition in my written testimony, but essentially that means any information that can specifically identify that individual, like their name and their address. And so, our proposal is kind of twofold. Looking back, we fully support the provision that would open up access to birth certificates unless there is that previously filed non-disclosure agreement on file with the adoption registry. There's already kind of a 2-year notification period in the bill so that anyone who does not currently have a non-disclosure request on file, but feels they need one, can submit one. And we request that this non-disclosure request also keep confidential that personally identifying information of the birth parent on the original birth certificate, not just the records in the adoption registry. However, we don't think that needs to preclude these adoptees, the small percentage of adoptees who that would impact, from obtaining their original birth certificates. We, as in hearing all of these stories, we want to find that right balance that serves both parties equally. And so we are suggesting that perhaps when there is a non-disclosure on file, that the adoptees can be issued a redacted copy of their original birth certificate that would include all of the adoptee information, such as their birth name and their place of birth, but would redact the birth parent's personally identifying information, which would really just be their name or address. And, there is already a process through which an adoptee can go and petition the probate court for the release of that personally identifying information if there is a non-disclosure on file. So that non-disclosure doesn't necessarily preclude, or the redacted copy doesn't necessarily preclude an adoptee from being able to petition the probate court and say, actually, I really need this personally identifying information, and here's the scenario. And the probate court finding that is a reasonable request, and the state releasing that information. And then, moving forward, our request is pretty much similar to our look back request. Currently, this bill doesn't provide that pathway for requesting that confidentiality moving forward. And we would like to see this pathway continue as it does in our current law for those very rare instances when a birth parent feels like that safety is needed. And we believe that non-disclosure form, which is currently being used, is appropriate. It's not a guarantee, but it does offer a way for birth parents to express their desires in keeping that information confidential. And then again, if adoptees have that NDA on file, but want a copy of that original birth certificate, that they could receive that copy with that personally identifying information redacted.
Mr. Chair.
Yes.
Jessica, I think I understand the concern and your proposal. I'm wondering, you refer to it as a narrowly tailored exception. Is there something in the language you're suggesting that would narrowly tailor it? Or are you just saying that you believe relatively few people would take advantage, but it could be a large number? In other words, if we change the law so that people are going to routinely be able to get access to their birth certificate, but we leave an avenue that's not a carve out for a specific population or a specific kind of proof, it's just an option, then, at the Lund home, for instance, that would be presented as an option, not just for people who are suffering domestic abuse, but for anybody, right?
Absolutely. Yeah, we've had multiple conversations with Lund and other stakeholders in this process, and have gone back and forth around is there a way that we self-certify or some sort of process that we identify that this is really needed for safety. And what we ultimately concluded is that already this is an option for anyone who wishes to use it. And a very, very small percentage of folks agree to sign or ask to sign this non-disclosure agreement.
Well, but I think an important thing there is that they understand now that the birth certificate is going to be is not routinely going to be released. So this bill would change that. So everybody would be informed at 18, your child is going to know unless you do this, which would be a different instruction to a relinquishing parent.
And Kate might be able to help me out here, but my understanding is that pre-1986, there was a presumption that those were sealed, but 1986 and forward, the presumption is that information is not sealed unless there is an NDA on file. And so that's the process we're asking to continue.
Okay, I just, in listening to the description of this remaining an option, it seems to me, we deal with a lot of issues here, and one of them is life without parole. And, we've struggled as a committee. What do we believe to be the principle, and what do we believe to be the practical application of the principle? So here, I think everybody believes in the principle that these adoptees have the right to the birth certificate. So I struggle with why we would put in practice going forward something that would continue to not just allow, but would almost encourage in the law an instruction for relinquishing parents that you have this option where you can prevent your birth child from receiving this information out 18 years. So I have to say, I like the way the bill is currently structured, where in the look back, we're honoring a promise that's already been made. But going forward, the instructions given at Lund and other adoption agencies would make clear that in 18 years, the child is going to have the right to petition for this. So I struggle with the need to protect somebody 18 years out, and that against the right of the child.
Yeah, I totally hear that struggle, and it's definitely something that we have been wrestling with as well. And I would say that we are definitely open to options that that narrow that request for non-disclosure even further. And at the same time, I feel like there are processes for an adoptee to get that information, but there isn't. If this bill were to pass, there isn't a pathway forward for that birth parent to be able to say, we'd like to keep this information private.
Yep.
So there's definitely I think there's a balance there.
Thank you.
Thank you, Jessica. Are there other questions for Jessica? I understand the concern, but on the other hand, I'm not sure how realistic it is to think that, when somebody turns 18, they're not going to get that information. Even if the state says you can't have it. I just think it's going forward, it's an unrealistic promise. I also am, just on a basic, sometimes we conflate getting the information with actually meeting the birth parents or parents. That doesn't necessarily happen. That's a different type of process. I can remember writing my sister and assuring her that I wasn't trying to ruin her life, but that I would love to know something. And 3 weeks later, I got a call from a woman, and as a state senator, you get frequent calls. And she said, "You wrote me a few weeks ago. I'm responding to your letter." And I was like, "Oh, who the hell did I write? How many people you write?" And it was my sister. And we had quite a long chat, and then we decided to meet in a fairly neutral place and have lunch together. So my wife and I drove down to just south of Greenfield, Mass, to Yankee Candle, and had lunch with her and her husband, and that was the first time we met. And from there, we got to know my nephews and their families and all of that.
Did she know about you?
She didn't know about me
She didn't know
until
about you till you
she got my letter. So she called the only living relative of my birth mother, who was an older aunt, and said, "Did you know about this?" And evidently the aunt did know, but had kept it a secret for 50 years. And then, come and behold, out through Ancestry.com, we both finally have another sister. So that's the history. I don't know that anyone goes out, haven't heard of adoptees who go out looking indiscriminately. It's just getting that information. And again, because of Ancestry.com, I think that it's an unrealistic expectation that they're not going to find out if they want to. For most, until I started to get older, I didn't really give a damn, to tell you the truth. I had great parents who raised me, and I knew I was adopted, but I didn't care until I kept getting questions about my health from my doctor, and I couldn't answer them, and nobody could. That was the reason. So just a little history. My mother was in a prison, so I guess she may have been a victim of abuse by her father. But back in the 40s, that's where we put people who were kids who were out of control. She was 18. So, obviously she had little choice but to give me up for adoption because she was in the Framingham Reformatory down in Mass. So just, I'm sure she had a very difficult life, much like many of the women that you work with. So that's just my story, and I just think it's unrealistic to think, at least going forward, that people aren't going to find out. Are there other questions for Jessica?
I mean, I just think the Kate from the Lund home had mentioned the Safe Haven Act. And that might be something to take a look at just to see how that works. And, as an alternative for that person who wants non-disclosure, they might try going that route. But I haven't read that either.
As I recall, that law, it allows the Secretary of State or allows the person who relinquishes the child not to be prosecuted for leaving it, because you have situations where a child is left at a hospital or a police station or at somebody's doorstep.
Yeah, it's not something that someone wants to do.
We'd have to talk to the Secretary. I think it's the Secretary of State that operates.
Yeah.
Any further comments, Jessica?
Well, I was just going to comment, if I could, about the safe haven laws, because I feel like in those instances, the adoptee has absolutely no records. They have no health records. They have nothing. It's not just personally identifying information. And so I would hate to, if that is kind of the option that a birth parent is considering, I would much prefer to have an avenue where an adoptee can have most of the information and an avenue towards reunification and getting that information than absolutely no information or no way to contact their birth parent.
Of course.
Thank you very much.
Thank you.
We actually have a witness in the room, so I'm gonna jump to him and then come back to Lori Canty and Judge Done, our final witnesses today. So Commissioner Brown, welcome back.
Yes, thank you.
I don't even think you were commissioner the last time you were in this room.
Probably not. It seems like a lifetime ago, though.
Yeah. Commissioner Sean Brown, Department of Children and Families. We're discussing the number 629, an act relating to adoption records.
Yes, and my understanding is I was prepared to talk specifically to section 6 and section 8 regarding the public notice.
Yeah.
In the implementation section. Effective date, date 9, excuse me. In terms of the public notice, we don't see that being something we do regularly in the department in terms of when we make changes. So it's something we think we can move fairly quickly to move forward, particularly the way it's laid out in the bill. We have staff who specialize in this area, and we don't anticipate that there'll be a huge expense to this, and whatever expense there is, we would be most likely able to cover within our existing budget and appropriation. So we don't anticipate needing to ask for any type of special appropriation for that work. That I think we can cover within our existing funds of the department.
Is the September 1st deadline reasonable?
I think it is. We would probably, just to give us a little wiggle room, just given the curveballs that have been thrown at us during the pandemic. I think maybe giving us till the end of the month would be helpful, but I think we could make September 1st work. But just to give us a little extra wiggle room, the 30th it might be better for us, but I think we could do it within the 1st. And then in terms of
October 1st,
that's fine. Yeah. Just to make sure if we do hit any snags or we haven't, and decide to retire unexpectedly or something, we can fill a position and just give us that flexibility, because we are experiencing a bit of turnover right now given the retirement changes and just where we are as a workforce. So, and then in terms of the rest of the implementation date, we would develop the forms and we would do the outreach, and I would defer to the committee whether, the July 1st, 2024 date, but, we certainly would, be working, with those that reach out to us that want to execute the forms and work to, document and record those in our records, and so that we can either make records available or not. So I think, it's up to the committee, wisdom to decide whether, that can be shortened or not. But I think, we'll be able to hit the implementation dates and do the outreach and be ready to go. Whether, the 24th is too far out or right, I would defer to the committee on that.
No, I prefer 23 a year if that's possible. I wondered why 2 years. I haven't heard any testimony usually.
And am I reading it right that it would be that the window to file one of these non-disclosures would be open to anybody who gave birth at any point? Is that your understanding? So it says, this is page 4, former parent of an adoptee filed a request for non-disclosure prior to July 1, 2024. The request shall be honored. So could this be a birth from 40 years ago and somebody now filed?
Yeah.
Because
That's how it reads, but
it seems a little odd to me that we would, in other words, they've gone 40 years without a non-disclosure, but we would be offering them or notifying them. Seems like we'd be deliberately upping the number of non-disclosure agreements with them.
yeah, I would actually, for the purposes of markup and bill, and when we go over it, I'd like to see a 23 date on that, but also discussion of whether even that is a policy that, number one, has any basis. Number two, is it real? I mean, I don't know how much Ancestry.com costs, but
You don't need it. You don't need it. You've got lots of advocacy groups that are talking to each other on how to get that information.
Michelle, did you want to comment on that?
I just wanted to address it real briefly. So the reason the date is tagged to July 1st, 2024 is that because they have that right now to be able to file for the non-disclosure, it's tagged to that same date as the effective date as of the other sections and the access to the original birth records. You can certainly change those, but that's why. So the idea was that to try to address some of the witnesses who are concerned about folks who have signed non-disclosures or who may not want identifying information released, to allow them to continue to file for that, and that would be respected with regard to identifying information in the registry, but it wouldn't serve as a bar to accessing an adoptee's original birth record. But it's just a policy decision for you. So you could do away with the disclosures now in terms of not allowing future access for filling out the disclosures, but
That'll be a policy decision of the committee, but I think generally I prefer to have it 23, not 24.
Sure.
If that's, as the commissioner said, he doesn't see it as a problem for the Department of Children and Families. Are there other questions of Commissioner Brown? Senator Nitka?
Well, this isn't usually in our committee here, but I think I heard that there was no request for any appropriation, which I have to admit is when these things suddenly open up, your registry person is going to be absolutely swamped. Similar to what we did with the courts, and the court had so many cases when we changed that piece of work that we just, the right to have an interim appeal,
right.
The interim piece for the record to be looked at if they were on furlough and were brought back. Remember the swamping that happened then with that. Certainly the same thing I think is going to happen with this, when suddenly things can be open and then someone, people getting the birth certificates, and then at the same time, many, of course, will ask for information from the registry, and I think they'll
Sure,
respond.
that is something we would certainly monitor very closely.
Yeah, I
And,
think
and we saw a surge and we needed to reallocate resources from within the department. We're a very large department, just like we've done from the pandemic. We have become quite skilled at moving resources to address workload issues where, where we see those surge. We've done it in
Could also
housing.
be a budget.
Yeah, and so we would certainly provide support to Christina's unit.
Yeah, right.
If you want to put an appropriation on, Senator, we can do that. All right. Christine, did you have some comments you wanted to make?
Thank you, Senator Sears. For the record, my name is Christina Schuma. I am the Vermont Adoption Registry Coordinator. I am a Lund employee on contract with the state of Vermont to provide them with services for the Vermont Adoption Registry. I just wanted to refer back to the timing of the enactment of the allowing for the original birth certificates.
I'm sorry, I'm still taking testimony and I'm not at markup, but if you go ahead quickly.
Yeah, the reason for the continuation of the July 24 date was to allow for birth parents to also provide the contact preference form. So that way adoptees had an understanding of what the potential expectation of contact might be with their birth family.
Okay, thank you. When we get to the markup stage, just realize that the committee is interested in the 23 dates. Any other questions for Commissioner Brown? Thank you.
Thank you.
Good to see you.
Thank you.
The next witness is Laurie Canty, the trial court operations department of the Vermont Judiciary, not the department. Laurie, welcome back.
Thank you. Good morning. Good morning. So Laurie Canty, I'm the interim chief of trial court operations. Is my understanding my testimony today is to discuss any concerns about impact on the judiciary. Having spoken to several of our probate courts and several of our experts, we don't anticipate a significant impact on the judiciary, so we're not concerned about that. The one section of the bill that I would raise perhaps a slight concern about would be under 5C under section 7, where it talks about making a determination. Before making a determination, the court shall make a reasonable effort to confidentially contact the person whose identity is being sought in order to determine their response to the petition. And, obviously that's something we will do, but it's, just concerned about the amount of investigative work that may need to go into finding addresses for people that are, probably living in different locations. And I've been told by one of our judges who's done that a few times in the past by reaching out and sending a letter that his response has been unanimously that the person is opposed to having the disclosure.
What does reasonable effort mean?
I'm sorry, I couldn't hear you.
It's going to be a lot of work.
Well, if reasonable effort is a certified letter to the last known address, then that's not a heck of a lot of work.
No, that wouldn't be onerous.
If reasonable effort is setting out a further attempts, then that might be.
Does it say certified?
No, it doesn't say anything about that. That's why I asked, what's reasonable effort?
Being added in the newspaper.
Yeah, add in the newspaper. Tell everybody about it. Put it in the newspaper. I mean, it should not be a certified letter. It should be just a regular letter, because that's alarming too if you get a certified letter. Everybody in the house wants to know what it says.
Right.
So, or in many households, you don't accept it.
Newspaper ad would be better.
I'm sorry. My question is, what does reasonable effort mean? And have we used that in the past, Lori, where for the court? And how do you usually look at that?
I think it's still open to some interpretation by the courts. I would agree that it would be a letter to the last known address. Again, I was told that the judge confidentially sent a letter, so I'm not sure what confidentially sending a letter means unless they send a letter and mark it confidential, but
That's sure to pique everybody's interest. Actually, this is the registry actually would do this, I think. Sorry, not the
It
court.
says the court should make a reasonable effort.
Where is that?
In C on page 8. It doesn't, I don't have.
Oh,
lines, so
on page 5.
It's page 8C. Before making a determination under this section, the court shall make a reasonable effort to confidentially contact the person whose identity is being sought in order to determine the person's response to the petition and shall consider any response in reaching its decision. Senator, Michelle, did you want to comment?
I just wanted to point out that the only reason that section is even in here is because I needed to strike some language to make it consistent with a policy decision in another section. That's current law, and it's just when someone is denied access to their birth record under current law, that's what the court does under current law. So there's no change in that standard at all. And there's going to be a lot fewer challenges, because if you stick with the policy that's in the version now, you're going to be allowing adoptees who are 18 years of age and older to obtain it. There's not going to be that kind of gatekeeping going through the registry. So I would imagine you're not going to have there's going to be a decrease in the probate division in terms of looking at appeals of decision of denial of access.
Thank you. Anything further for Lori? Lori, thanks so much. Appreciate you being here today.
no problem.
Judge Zone, welcome back.
Thank you.
We're
Good morning.
I see it's open behind you. The
Yes,
sign is open.
we are open for business today here. Absolutely. If I turn it around, then that means my day's over. So I try to. For the record, Tom Zone, Chief Superior Judge. For background, what I did after receiving H629 is I sent it to the probate judges and asked for input. They're the ones who deal with these issues frequently. I can tell you that the view that I was told from the probate judges is virtually unanimous, that this is, as this committee has been talking this morning, and I've been listening for a while, this is a policy decision. And so the probate judges indicate it's policy on important and very deeply personal matters. There were two judges I know at least who indicated concern about retroactivity. I've listened this morning, and I think those are concerns that come in with respect to the testimony you've heard and policy determinations that you're going to make. Also, I think that the policy decisions obviously are ones that take into account, as you've been talking about this morning, the practicalities and realities that we now face in our technological and scientific world, whether it be through Google or Ancestry.com. A question was recently asked in the past few minutes about reasonable efforts. There's a Judge Len Edwards out of California who travels the country lecturing on juvenile matters, and we hear about the term reasonable efforts in juvenile cases. And Judge Edwards has in a paper that he wrote, reasonable efforts is a term that confounds judges and lawyers alike. The Vermont Supreme Court has defined reasonable efforts in the context of the juvenile reasonable efforts finding as the exercise of due diligence by the Department of Children and Families to use appropriate and available services to prevent unnecessary removal of the child from the home or to finalize a permanency plan. And I would gather from that, because we're talking about children here, that a fair reading would be that it's the exercise of due diligence as far as the obligation of the court. Unfortunately, I think we're back to Judge Edwards, because there's no specific what exactly is due diligence. And I think what we would look at for that term is that the exercise of due diligence will really be fact dependent upon the information available to the court and the current circumstances. And so I regret that I'm not able to say absolutely X, Y, or Z will always be reasonable efforts, because it will be heavily dependent on the specific facts before the court at that time.
Oh, that's very helpful, actually, Judge. So I appreciate that.
But unless the committee has any questions.
I don't think I have at this point.
Well, thank you. And I'm now, for the morning, I'm going to turn my open sign to the other side and take a lunch break.
Okay, you're closed. Closed for lunch.
Thank you. Have a good day. Take care.
Committee, Michelle, can you join us for a few seconds? I think we're going to hear from David Englander tomorrow, and from the Department of Health. And then I think we'll be ready to do some markup. I think you've already kind of heard some of the concerns, so the flag possible changes are on the dates and section 4 about requests for non-disclosure and how that all is gonna, if that should be there, and how it should be handled if it is. The rest of the bill, we agreed with in section 8, not the report, not later than October 1st for the Department of Children and Families. So that's one minor change.
Report? Report.
Page 9, section 8. The first item, not later than October, it says September 1st, 22, the Department of Children and Families shall develop contact preference forms and make such forms readily available to the public and initiate plans to notify members of the public about this act.
So not a report.
Well,
Not a report.
implement that, yeah, you're right. I used the wrong term. But no later than October 1st, they would have the forms ready and initiate plans.
What about the issue of using the word former? I know Michelle.
Well, that's one that we could tackle, but I think it has to change everywhere else in the law.
It would have to change many places.
It would.
I know, that means that they'd have to do it
when they do the rewrite on the summer or whatever.
well, if they are doing that volume, when they do that volume, they could change it.
Yeah.
Yeah, okay. That's the issue of former parent, the terminology.
Versus birth.
I will just note, and you might want to hear from some of the practitioners, is I think while the circumstances are probably very few, there is a difference because you have birth parents, but you also may have a former parent who was not a birth parent, because the way that the definition is in current law for former parent is a parent who had their rights terminated. And so it could be, I think it's intended to encompass, like if there was a child who was adopted and then the adoption was undone and that parent's rights terminated. And so it may be more than just doing a kind of a search and find substitution. So I just want to raise the issue that I think it might be a little more substantive, and you might want to take testimony on that.
Okay.
I don't think.
I understand what you're saying, but the fact is these people don't care about those parents. They care about the birth.
I understand, but.
Yeah, I see what you're saying.
Given the time that we have left in this session, it might be a little bit much to take on.
Yeah, I wouldn't want to hear from anybody else anyway.
I
know.
Okay, so,
Of that group of formers, you know, who are not the person who's.
for tomorrow morning, Peggy, just put, committee discussion and markup.
Okay, and it's not,
After we hear from David, it's actually not gonna be David Englander, but that person from the Department of Health that he's gonna have.
So Senator Sears, the only changes that I heard you say that you definitely want in a draft are the two date changes. One with regard to DCF doing the notification and having the contact preference forms done, moving that to October 1st, and then making the bill effective generally on July 1st of 2023 and 2024, right? And then the issue around what to do around non-disclosure forms, y'all are still discussing that and working on that tomorrow, right?
I think our main topics for review will be section 4.
Right, but you're not directing me to make any changes to section 4 right now.
Well,
Are you? Pardon?
We would make one change, and that's to make information prior to July 1, 20.
Oh, sure, the dates. Yep.
But
Yeah.
there may be other requests. There may be those of us on the committee who don't think it's realistic to non-disclose.
Okay. I just wanted to make sure you didn't want me to change that substantively other than the dates for tomorrow.
For tomorrow, no, just
Okay.
that. But I think our main discussion tomorrow will be on that issue of disclosure. Given the testimony from adoptees, birth parents, and others who've been here from the beginning, and then the testimony today from both the Network Against Domestic Violence and Sexual Assault and the Lund Home. So both had suggestions, and that's, I think, those are the main topics left here. Okay.
Yep, good.
Great. Thanks, everybody, for hanging in there.